rights and protections that the Constitution provides in our interactions with our judiciary. I'm Stephen Arms, and join me in If you've been following my videos, which you should be, I've dealt with the First through the Fifth Amendment individually of the Constitution. Since the Sixth through the Eighth all relate to the judiciary, I'm going to tackle them all in this video. Now, first of all, my apologies, though, for not posting a video last week. My wife had the flu, and since she helped me with handling my videos, say hello, Valerie.
Hello.
She's feeling better now, so we're doing one. We'll get back on normal schedule. The Sixth Amendment of the Constitution is,
in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime has been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense.
the Sixth Amendment guarantees the rights of criminal defendants. You're guaranteed a right to a public trial without unnecessary delay, which is generally not considered to be not more than a year. You have a right to a lawyer or an attorney. You have the right to an impartial jury of your peers. And you have the right to know who your accusers are and the nature of the charges of evidence against you. Most of what we've established in this amendment are parts of British common law. They go back almost all the way to the Magna Carta. You have a right to, again, this is when you watch your TV shows, you have the right to attorney and all that, and the evidence against you, and all the things they always say when they read your Miranda rights, which actually only were established in the late 50s, early 60s as being required to be done by people when they were arrested. Many elements of this are tested, especially in specific types of trials, for example, terrorism. It also figures in cases where that involve jury selection. Do you have a right to have an impartial jury, so therefore you can't have your cousin or people who have undue prejudice against you on the jury. Also, in some cases, the matters of who you're being charged with, who's charging you, and the accusers involved in it can be a little bit sticky if you're dealing with, say, witness protection program situations, sometimes involved with sex crimes to protect the people who have been attacked, especially in the event of dealing with minors. And also, of course, in criminal activities where you might have retaliation against the person. So there are some fine lines in it, but generally speaking, these are all designed to give you the right to a fair, speedy trial where you know who your accusers are, you have a right to hear the evidence, know what the evidence is, you have the right to find your own witnesses for your defense and produce against you, and they are supposed to be public. Now, again, there are exceptions to that too, and there obviously could be some ones, but a public trial is a simple guarantee for the idea that in the light of day, people see the truth. Okay. The Seventh Amendment is,
in suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law.
Now, the Seventh Amendment definitely continues the practice from British common law of distinguishing civil claims, which must be tried before a jury. Now, you don't always have to try before a jury. You can present the parties involved in it can put an absent waiver, which means in that case it can be ruled by a judge alone. Their claims and issues can be heard by a judge, and the judge can make a ruling by themselves. But the idea of it is that, again, the old 12 jurors of your peers to give an honest opinion. This, of course, since this is the Constitution, though, even though it deals with matters of civil law, it only applies, of course, to federal civil courts, not to state courts. For example, they can have different rules though they generally adhere to, they can't vary too much from the Constitution because it'll put them as in opposed to the law, and the Constitution always wins in those arguments. Now, the Eighth Amendment is
Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted.
the Eighth Amendment deals also with excessive fines and bails. The excessive fine clause surfaces in many places, but most specifically in matters of civil and criminal forfeitures. For example, when the property is seized during a drug raid. Now, forfeiture, of course, is government seizure of property connected with illegal activity, and it has been a major weapon of the federal government's war on drugs. The only problem is it can easily be abused, because if an individual is arrested, it doesn't mean that they're guilty. You have to convict them. You arrest them, you charge them, you bring them before a jury, and then the case is decided, and they're either found guilty or innocent. At that point, if they're guilty, then the illegal gains they've got from their criminal activities it can be sold by the government. The problem is, if the trial takes a long time, the government doesn't always want to wait for that. There's a lot of police departments, a lot of areas where they're definitely concerned with the idea of, well, let's say sell all this property and make a lot of money. And then if that person is acquitted, perhaps there's a consideration of how you're going to pay them back. I mean, if you suddenly, well, we got an extra $50 million in our budget, well, now the person's acquitted and you owe them $50 million. It can easily be abused, and in some ways it reminds me of the current situation that's happening with harassment accusations in our country. Accused is not convicted. I mean, you have to be put on trial and then convicted, and that's one of the issues I have when someone says all accusations should be listened to. They should, but then all accusations aren't necessarily true, and they have to be provable in a court of law. Because even if it's not a criminal accusation, they're still civil matters. You can always sue someone civilly on an issue. Because people always forget that the point of the judiciary in theory, that the judiciary is a force of law that is designed to bring forth the truth, and that the truth is never wrong. We need to be very careful of that in this country, because knowledge and truth are the best weapons that exist against tyranny. For the power of tyrants of any sort flourishes in the foulness of deception and in the oppression of the truth. And my point on this video, I think, is, other than explaining some of your rights dealing with the court system, which is what the main purpose is, look at your society around you. Think about the ideas I've been talking about and consider yourself to be warned, because some of those pieces of tyranny do pop up occasionally, even in American society. So if you enjoyed this video, please hit the like icon and share my site with others. And of course, subscribe. Until next time, battle on for truth.